Hello,
Hello
everyone.
everyone.
I'm Liven.
I'm Nomsa and welcome to Group 5 presentation. We are law students from the University of Zimbabwe. Before we begin, I would like to recognize our esteemed lecturers, Mr. Maposa and Ms. Chikuru. Our Group 5 members comprise of Austin, Munashe, Liberty, Victor, Richard, Isabel, Tandiwe, Alex, and Austin.
So on this interesting topic, we're going to be presenting on the legal regulations of telecommunications. So the presentation is going to take an inverted funnel approach, whereby we will be starting by looking at what is telecommunication, what is ICT in Zimbabwe, and also looking at the local perspective of legal regulation of telecommunication, and also looking at the regional perspective of legal regulation of telecommunication, and finally on the international perspective of legal regulation of telecommunication. So now I'm going to hand over to Isabel, who is going to be looking at the position of ICT in Zimbabwe.
As alluded to by my colleague, I am focusing on the functions of ICT. ICT in Zimbabwe falls under the Ministry of Information, Technology and Career Services. It is divided into four main categories, which are computing and information technologies, broadcasting, which is divided into radio and television, as well as telecommunication and internet. The ministry's mission statement is to transform Zimbabwe through use of information and communication technologies into a knowledge-based society so as to enhance the country's competitiveness in the world in order to stimulate and sustain economic growth. Now I'm going to focus on the functions of the Ministry of ICT. The Ministry of ICT is mandated with creating and enabling environment for creation of an e-knowledge-based society that transgresses across all levels of society. It also focuses on developing, in conjunction with the relevant ministries, a strong ICT human resource base in the country. It also focuses on spearheading the development of appropriate regulatory framework that facilitates the promotion of ICT. It is another thrust of the ministry is championing and promoting ICT literacy in order to enhance regional and international competitiveness as a nation. The Ministry of ICT also thrives to create a conducive environment for investment in the areas of ICTs through public and private partnership in all sectors. I'm now handing over to my colleague Austin, who is going to focus on Zimbabwe's legislative and statutory framework. Thank you.
Like said by my esteemed colleague Isabel, I'm presenting on the Zimbabwe's legislative and statutory framework. The telecommunication law pertains to the system of electronic communication and broadcasting across Zimbabwe. This area is regulated by Postal and Telecommunication Regulatory Authority of Zimbabwe, that is POTRAS, which is established in terms of Section 3 of the Postal and Telecommunication Act, Chapter 12.05, which says that, I shall quote, there is hereby established an authority to be known as the Postal and Telecommunications Regulatory Authority of Zimbabwe. We shall be a board corporate capable of suing and being sued in its corporate name and subject to this act of performing all cases that bodies corporate may by law perform. The regulatory authority in terms of section
Go, Austin.
This regulatory authority in terms of section 4, subsection 1, paragraph A to paragraph 4 is allocated functions and powers in which the board must act upon. These include but not limited to: 1. Ensuring the provision of sufficient domestic and international telecommunication and postal services throughout Zimbabwe on such terms and conditions the authority may fix. Then number 2, it also promoted the development of postal and telecommunication system and services in accordance with the practicable, recognized international standards and public demand. It also exercised licensing and regulating functions in respect of postal and telecommunication systems and services in Zimbabwe, which include the establishment of standards and codes relating to equipment attached to telecommunication systems, among many functions that it can perform. We also have an important document or a statute or ICT statute that we have in Zimbabwe, that is the Constitution of Zimbabwe of 2013, which is considered as a progressive document with regard to its expansive view of rights. This document, while is not categorized in respect to ICT and internet, they are viewed and considered evidence of enjoyment of rights. The Constitution, as we all know, in terms of Section 2, it is the supreme law of the land of Zimbabwe that is in its class of N, that is sui generis, and all other laws, customs, and practices that are inconsistent with the Constitution, they are declared null and void by the competent court in Zimbabwe. In terms of Section 51 of the Constitution, we have a right to human dignity, which must be protected. We also have the right to privacy, which is defined by the dictionary, by the Black Laws Dictionary, as the right to be let alone, the right to be free from unwarranted public, the right to live without unwarranted interference by the public in matters which the public is not necessarily concerned. The Constitution, it also, in terms of 327, is highlighted how international and local or regional conventions are incorporated in our law. We also have an important ICT document or telecommunication law document that we have in Zimbabwe, that is the Data Protection Act, Chapter 11.2. This act provides for data protection with the due regard to the Declaration of Rights under the Constitution and the public interest. It also applies to matters relating to access to information, protection of privacy of information, and processing of and storage of data, wholly or partly by automated means. Section 5 of the Data Protection Act, it also designates the Postal and Telecommunication Regulatory Authority as Data Protection Authority. Now, this is the end of my presentation. I went over to my colleague Munashe, who will present on the regulation and freedom of the media in Zimbabwe.
Regulation and freedom of the media in Zimbabwe. This right is enshrined in Article 19 of the Universal Declaration of Human Rights. It is also provided for in the International Covenant of Civil and Political Rights and Article 9 of the African Charter on Human and Political Rights. Zimbabwe has ratified the aforementioned conventions. Section 61, subsection 1 of the Constitution of Zimbabwe stipulates that every person has the right to freedom of expression. This position is further buttressed in the Supreme Court case of Chavunduka versus Minister of Home Affairs and another. Freedom of media encompasses the media's ability to establish and operate free from state molestation. However, this has some limitations. For example, freedom of the media to distribute pornographic material may not be acceptable at law. Freedom of the media is meant to include protection of confidentiality of journalist sources of information. I will hand over to my colleague Victor, who is going to present on regional regulations.
As alluded to by my colleague Munashe on the previous presentation, I'm going to be focusing on the regional regulations of telecommunications. Now, within the SADC region, within which Zimbabwe lies, there is the SADC Declaration on Information and Communication Technology, which in itself is a broad policy framework for the entire region in terms of coordinating, cultivating, as well as deepening this increasingly important field of ICTs. So within the SADC region, countries have come together to come up with a broader policy framework of how to govern and regulate policies within the ICT sector. With this framework, there is a declaration on ICTs which was established as a coherent policy on ICTs for SADC member states as they endeavor to bridge the digital divide between the SADC and the rest of the world. There's been a constant desire for the SADC region to catch up with the rest of the world in terms of ICT regulation and ICT development. The areas of concern include advocating for improved regulation environment and encouraging community participation in terms of the development of ICTs. This highlights the importance of ICTs and ICT-related infrastructure. For instance, in 2012, the SADC released its Regional Infrastructure Development Plan. This development master plan was meant to promote the development of 4 strategic pillars within the ICT sector, and these pillars included infrastructure, capacity building and content, e-service and applications, as well as research, innovation, and industry development. I'll be handing over to my colleague Alex to take you further on the international framework of ICTs.
As already mentioned by my colleagues, we have discussed the local framework as well as the regional framework. I will be focusing on the international framework. Essentially, the International Telecommunications Union, ITU, was founded in 1865 to facilitate international connectivity in communications networks, to allocate global radio spectrum and satellite orbits, to develop the technical standards that ensure networks and technologies seamlessly connect, and to strive to improve access to ICTs to underserved communities worldwide. The International Telecommunications Convention is the basic treaty that established the legal basis for the International Telecommunications Union and defines its purpose and structure, including the protocols and obligations on members. The treaty is the founding document of the ITU, which is a specialized agency of the United Nations. The convention was concluded on 22 December 1992 in Geneva. The ITU is now one of the most complete global international organizations. It comprises 46 member nations divided on a global regional basis. For example, the Americas have 8 seats, Western Europe is 8 seats, Eastern Europe is 5 seats, Africa is 13 seats, Asia and Australasia 12 seats. Presently, the ITU comprises 192 member states, 136 sector members, and 145 associates. The preamble of the Constitution reads, While fully recognizing the sovereign right of each state to regulate its telecommunications and having regard to the growing importance of telecommunications for the states parties to its constitution as the basic instrument of the ITU. There's an Article 1 which focuses on purpose, Article 2 which focuses on the composition, Article 3 which focuses on the rights and obligations of member states, Article 4 refers to instruments. There's also the ICT Regulation Toolkit to provide practical advice and concrete best practices guidelines to enable access to ICTs for all. Others may ask why regulation is important in telecommunications. The long and short answer to this is quite obvious. One, in order to transition to an effective competitive environment, regulation creates a platform to oversee introduction of competition as well as prepare incumbent operators to face competition. Secondly, to allocate and manage scarce resources in an equitable way. Thirdly, it does expand access to telecommunications. Fourthly, to promote prices that reflect efficiency and ensure there is access of services by those who may not have the capacity to access such services. Having concluded on the international side of things, I now hand you over to my colleague Tandiwe, who will now do the conclusion and touch on a few things.
As I conclude to what has been said by my fellow colleagues, there is a serious need for regulatory intervention. Regulation of the telecommunication sector ensures growth and stability, while at the same time preserving privacy and ensuring effective competition. It is generally accepted that once a fully competitive environment is attained, the need for regulation reduces. The implementation of an effective regulatory framework sometimes results in greater economic growth, increased investment in more efficient technologies, lower prices, better service quality, higher penetration, and increased innovation. In fact, investors view the regulatory environment as a critical benchmark in deciding whether to invest in a country. This marks the end of our presentation. Thank you all for watching.